says harassment means unwanted conduct which is persistent or serious and demeans, humiliates, or creates a hostile or intimidating environment. All of which I've already argued is precisely what we say the statements were intended to do, or is calculated to induce submission by actual or threatened adverse consequences. Again, I've made submissions about that, and which is related to, the first is A, sex, gender, or sexual orientation, or B, a person's membership or presumed membership of a group identified by one or more of the prohibited grounds, or a characteristic associated with such group. So your ladyship will see that common both to hate speech and harassment is the concept of the prohibited grounds. It appears in both. Now, the definition of prohibited grounds, which is also in Section 1 of the Act, has two parts to it. Part A specifies certain specific grounds, and Part B opens the list to other grounds that are not specified, but which may yet be held to be part of the prohibited grounds. Part A includes race, gender, sex, pregnancy, marital status, economic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, birth, and HIV/AIDS status. So it's either A or B. B is any other ground where discrimination based on that other ground, 1, causes or perpetuates systemic disadvantage, 2, undermines human dignity, or 3, adversely affects the equal enjoyment of a person's rights and freedoms in a serious manner that is comparable to discrimination on a ground in paragraph A. Our submission again is that in Part B, 1, 2, and 3 must be read, I think the word is disjunctively, I'm not sure if that's correct, but in plain terms, what I'm saying is that after 1 there should be an or, after 2 an or, 3 an or. So it's 1 or 2 or 3. So what is clear, my lady, in our submission is that the grounds in Part A of the definition do not constitute a closed list, specifically because of what is contained in B. The harassment and the hate speech that is directed against the journalists, I submit to your ladyship it's common cause that speech and those tweets are directed at those journalists, and in some instances journalists generally, because of the particular work they do as journalists. Put differently, because of the particular beliefs or opinions that they articulate as journalists. So our submission, which we make in paragraph 23 of our heads, is that we're not saying that journalists should constitute a prohibited ground. That would be too narrow. What we're saying is that occupation should constitute a prohibited ground by virtue of Part B of the definition. Because we say that discrimination based on occupation certainly meets the test postulated in B1, 2, and 3. And one can think of, if one takes journalists out of the picture, if one brings another occupation, for example, the occupation of sex workers, one can see why, in our submission, that if one were looking to, if there was discrimination against sex workers, I'll give an example. Perhaps someone who was previously a sex worker now applies to be a teacher and discloses his or her past occupation. It's conceivable that there could be discrimination against that person based on their previous occupation. Or things could be said about someone. Or a person could be harassed as a result of their particular occupation. It doesn't have to be limited to journalists. Now, B1, part B1, says it must cause or perpetuate systemic disadvantage. B2 says, or it can undermine human dignity. And there's a lot of talk in the papers from the various complainants about how their dignity has been undermined. And even if the test is objective, milady, some of the things, most of the things that are said about these journalists would certainly undermine their human dignity. The third one says there's got to be the manner in which the equal enjoyment of a person's rights and freedoms is affected must be comparable to discrimination on a ground in paragraph A. And so in other words, there's got to be some comparison done. And we submit that what characterizes all of the grounds in part A of the definition is that they all contain within them an element of vulnerability. Each and every one of them. It doesn't mean that everyone in that group necessarily is vulnerable to discrimination. But there are parts of the group that historically or currently are vulnerable to discrimination. So for example, if one takes sexual orientation as an example, immediately one looks to, if a person is discriminated against because that person is gay or bisexual or lesbian, one can see how the Equality Act would protect such a person if there's been hate speech directed against them, harassment directed against them, discrimination directed against them. But it doesn't mean that the category of sexual orientation won't be open to a person who is discriminated against or harassed or where hate speech is directed at that person who is not gay or lesbian or bisexual but happens to be straight and is abused by virtue of that fact. Now, straight people historically haven't been discriminated against. Hence, we make the argument that within each of these classes, each of these grounds, there is an element of vulnerability. It's not that the whole class is necessarily vulnerable, but the protections, milady, the protections apply across the ground, across the class. So the same can be said, we submit, about occupation. And it's strange that occupation is not, it should have been a listed ground, but it's not a listed ground. And we submit that it can come in under part B of the definition.
But what is your comment about the legal issue raised by the respondent? Do you agree that Section 10 of the Equality Act does not protect journalists from the effect of hate speech?
No.
Because that's the legal.
No, that is their submission. So,
Yeah.
my lady, their submission is, well, they say journalists are not
Protected from the effects of yes.
Yes, from the effect or do not fall within the reach
Yeah.
of Section 10.
Yeah.
There's an argument that I've just glanced at, and I haven't, because it's in our learned friends' heads of argument for the first time, but they talk about these grounds are characterized by immutability. And it's only if a ground is immutable that it can be included under Part B of the definition. Now, being a journalist, they say, is not immutable because you can be a journalist or not be a journalist. It's not something that is innate, although some journalists might disagree with it. Our submission is at least twofold. Number one, the case that our learned friends rely upon for this proposition of immutability didn't actually deal with this issue, and was certainly not dealing with the definition of prohibited grounds under the Equality Act. But even within Part A of the definition, it can't be that immutability is the test, because even if one looks at Part A of the definition, there are some grounds there that are not immutable. So, for example, well, this might be a debatable point, but I'm comfortable to make the submission that religion is not immutable. Conscience is certainly not immutable. Belief is certainly not immutable. I would submit that culture too is not immutable. And language. But let's deal with the obvious ones like conscience and belief. Those are certainly not immutable grounds. And there's no authority of which we're aware that says all of the grounds in Part B must encapsulate immutability. Can I also make this submission, my lady? The journalists who are targeted by the respondents in this case have been targeted because of their belief, have been targeted because of their conscience. These are journalists who publish opinion pieces, who do investigative journalism, who write about their opinions. So if one wants to look at the class of journalists that is being targeted by the respondents in this matter, there's an argument to be made that they fall under Part A of the definition, that they are being targeted, as the respondents say, precisely because of what they say. But we submit that doesn't detract from our argument on Part B of the definition, that occupation is a ground that satisfies all the requirements of Part B of the definition. And if your ladyship is with us on Part B, that occupation ought to be regarded as a prohibited ground, then journalists, then attacking someone because of the work they do as a journalist, besides the fact that you're attacking them because of what they say as journalists, certainly would qualify under Part B of the definition. So the particular journalists who are being attacked in this matter, in our submission, fall under both Part A, because they're being attacked on the basis of their conscience and belief, and Part B because they're being attacked by virtue of the work they do as journalists. So we make that point in paragraph 24 of our heads. And in 25 we say that the present matter is a good example of how hate speech and harassment affect journalists, both professionally and personally. Because what the respondents have done in threatening and harassing the complainants and other journalists, and condoning repeated abuse, harassment and intimidation by their supporters against these journalists, either expressly or by remaining silent. What they have done is that they have enabled or created an environment in which the abuse, intimidation and harassment of journalists is encouraged. And then this, we say, undermines their dignity. We deal with that in 26. And it has had the effect, the ladyship will recall, under the definition of harassment, I read to you that the unwanted conduct must be calculated to induce submission by actual or threatened adverse consequences. And many of, well, not many, but some of the journalists have toned down their reporting because of this fear that they may be subject to attacks by the respondents or their supporters if they report critically on the EFF. But my lady, the very job, the very profession that the complainants follow puts them in a space where they, because they are political reporters, because they are investigative reporters, they are going to investigate and talk about and opine about politicians. So it puts them in a space where they are going to be writing about these politicians. And if they are writing honestly, or what they believe, in their belief, is honest opinion, the probability of them clashing with the politicians is particularly high. It happens all the time that reporters who write politically and who opine politically write critically about the politicians that they investigate. And so when it happens that they write critically about the EFF or Mr. Malema, then they become susceptible to attack by the politicians themselves and their followers. And we say that vulnerability is comparable to discrimination on a ground in Part A of the definition. Because it's by the very nature of the work that they do that they are going to come into conflict with politicians. And it is by the very nature of the work that they do that they render themselves or expose themselves to being vulnerable to these attacks. Now, to answer your ladyship's question about Section 10 not protecting journalists, we say that everything in our constitutional dispensation is directed, well, not everything, but there are particular aspects of our constitutional dispensation that are directed in favor of the protection of journalists. We say that because, first, we start with Section 16 of the Constitution. And as I said earlier this morning, Section 16 specifically protects, besides freedom of speech and expression, it specifically protects freedom of the press and other media. We say it does that because it recognizes the vulnerability of journalists and the vital role that they play in sustaining our democracy. In fact, my lady, journalists or the media the media is the only profession that is expressly protected by our Constitution. We make the point in 29 that hurt or harm in the context of the Equality Act is not limited to direct physical harm, and it extends to an attack on dignity. I'm not going to read everything, my lady, but there is a reference there to the Supreme Court of Appeal decision in Wachanuka, in paragraph 29.1 of our heads. In paragraph 30, I deal with the definition of harassment, which I have already dealt with. And in 31, my lady, that this has been unwanted conduct which is persistent, that the individual complainants say as much, so subjectively they say that is so, objectively we submit that must be the case. And in 32, my lady, we make the point that because of this hostile and intimidating environment, journalists have already started to have fears or reservations about reporting on the respondents. We refer to what Ms. Munsani says in 32.1. She says that she's finding it increasingly difficult to do her work. Ms. Van Wyk says the same. She says that the aim of the comments or tweets were to shut me down and to stop me and journalists like me from writing articles that are critical of the EFF and its leaders. Mr. Basson is concerned, particularly about the effect on young journalists. Mr. Basson says this is likely to have a chilling effect on a younger generation of journalists. Now, my lady, no doubt the respondents will argue, well, this is what they say, how can we believe them? These are their fears, but if they just wrote as responsible journalists, they wouldn't suffer any of this harm. Yes, this is what they say. But objectively speaking, this must be the case. If one is a journalist who is a political reporter, an investigative reporter who writes critically about politicians, if the politicians about whom you write are not going to accept that you have a right to write critically about them, but instead are going to attack you and to incite their supporters to attack you and stand by whilst their supporters are attacking you, then you would be crazy to continue doing that, because ultimately it's going to end very badly for the journalists concerned. It can't be simply that Mr. Malema can say, all of this will stop when you start acting professionally. What that means is that Mr. Malema has taken it upon himself to decide, or the EFF have taken it upon themselves to decide, when the harassment, abuse, intimidation of journalists will stop. And they say that will stop when you start writing things that don't make us upset, don't anger us, don't cause us to say these things about crushing the enemy. My lady, that can't be right. Now, the respondents say that the claimants haven't relied specifically on sections 10 and 11 of the Equality Act. The affidavits we submit are clear, my lady, that the statements constitute hate speech. Ms. Matlasi says a number of times in her affidavit, which the others have all signed on to, that this constitutes harassment of journalists. The very relief, my lady, which is sought is relief which stops the harassment and the hate speech and the attacks on the journalists. The Equality Act deals with 3 issues, and 3 issues only: unfair discrimination, hate speech, and harassment. I thought there was a problem. The relief that is sought specifically speaks about hate speech and harassment. It's a legal question whether or not what is described in the affidavits constitutes hate speech, whether or not what is described in the affidavits constitutes harassment. If it does, and your ladyship finds that journalists are entitled to seek relief under the Equality Act, then certainly the complainants will be entitled to the relief sought. There is a paragraph in Mr. Malema's affidavit which says that the complainants have abandoned reliance on Section 11 of the Equality Act. Ms. Matlasi explains that in the replying affidavit, and the position is simply this. The complainants sought to add to the relief that is claimed in Annexure B. The relief that they sought to add was, in addition to interdictory relief, which is what is claimed, they also sought declaratory relief. An order declaring that certain words and conduct constitutes both hate speech and is harassment. The attempt to introduce the declaratory relief was opposed by the respondents. And because that was going to cause the matter to be postponed even further, and in fact today was going to be used to argue whether or not we should be entitled to extend the relief, the claimants withdrew the affidavit seeking the additional relief. But what was withdrawn was an affidavit seeking both hate speech and seeking a declarator that the statements constitute both hate speech and harassment. There's no basis for suggesting that the complainants waived any reliance on Section 11 of the Equality Act. Now, my lady, the position of the respondents is slightly curious on the issue of the protection of journalists, because they say that they accept that the Constitution protects freedom of expression, they accept Section 16 of the Constitution. They say that journalists should be free to work in an environment free of harassment. This is in paragraph 39 of our heads, and the reference to Mr. Malema's answering affidavit is there. But Mr. Malema says it is part and parcel of certain jobs that no matter how professionally one conducts oneself, one is still at risk of abuse. So the respondents are saying, yes, the Constitution protects freedom of expression, but journalists are not entitled to relief qua journalists under the Equality Act. Milady, in our heads of argument, we've highlighted various judgments of our courts regarding the importance of the media. I'm not going to read that out. We refer to the Van Breda judgment, the 2017 decision of the Supreme Court of Appeal. There's Kumalo versus Holomisa, again, the Supreme Court of Appeal. There's National Media Limited versus Bukhoshi, 1998 Supreme Court of Appeal. And it's all about the importance of a free and robust press to our democracy. And the same position was articulated by this court in 1995 in government of the RSA versus Sunday Times newspaper, and that's at paragraph 40.4 of our heads. But, milady, the important point is this. How can you guarantee the protection of the press and other media without guaranteeing the protection of journalists? The Constitution says there shall be freedom of the press and other media. The cases say we must protect our press because because the media play such a vital role in our democracy. The simple point, milady, is that the media constitutes or is made up of by the people who work in the media. The people who work in the media constitute the media. Yes, there are production houses and corporations, but the people, the individuals who report, who articulate their opinions and their views, those people, those are the individuals who are the journalists. And if you don't protect the journalists, if you can't protect the journalists, then to talk about protecting the media and other press with respect is meaningless. If one is going to protect the media and other press, then one has to protect the journalists. And we have to protect the journalists from hate speech, and we have to protect the journalists from harassment. Because if we don't, it's going to be open season on journalists that is hurtful, harmful, incites harm, promotes hatred, or is calculated to induce submission. A compliant press is the last thing we need in this country.
But the freedom of expression and of the media, Mr. Berger, is not unrestrained. Is that correct? The Constitution allows for its limitation in certain instances.
Yes.
Do you agree with me?
Yes, I do. And milady, that leads me into another point that I can deal with right now. The Constitution and the Constitutional Court and other courts have said quite clearly that the freedom of the press is not unrestrained. But the courts have said that our law of defamation is what restrains the media. So the media can't publish statements that are defamatory unless they can prove certain defenses. And what our law does is it places an onus on the press to justify the publication of defamatory statements. You can, as your ladyship knows, truth and public interest, protected comment, and most recently from Bukhoshi, reasonable publication. There's also qualified privilege. But it's the law of defamation which puts an appropriate limit on freedom of the press and the media. So, my lady, quite rightly, if the respondents and Mr. Malema, EFF and Mr. Malema have a problem with any journalist, they can sue that journalist for defamation. they can report that journalist to the press ombudsman. Our learned friends say that that's ineffective. But that is the regulation that is put in place, certainly with the press ombudsman. But our law of defamation is not ineffective. An adverse costs order against a newspaper will hit hard. And in the days of now, our courts are getting more creative with costs orders. There's the possibility that there could be cost orders against individual journalists, if appropriate. So our law is capable of limiting journalists in what they write and what they say. But, my lady, that's a different debate with respect from protecting journalists from the consequences of hate speech and harassment. Because then what is happening is one isn't limiting what they say, one is seeking to shut them down. If a journalist is threatened with physical harm or psychological harm, or a journalist's family is threatened with harm, that has the capacity of shutting that journalist down for good. And that's not limitation, that's just a shutting down. We submit that by protecting freedom of the press and freedom of expression, one allows journalists to operate in that protected space, but it's not an unlimited space. Once they behave in a certain way that is beyond the space, their particular speech will attract negative consequences, and negative consequences from the courts or other regulators. So, my lady, we submit that your ladyship has jurisdiction to entertain this complaint, and that the complainants are entitled to relief in terms of Section 21, subsection 2 of the Equality Act. As I said, the relief that they seek is set out in Annexure B, and Section 21, 2 of the Equality Act says, after holding an inquiry, the court may make an appropriate order in the circumstances, which means we submit that your ladyship is entitled to make any appropriate order in the circumstances, including if an order restraining unfair discriminatory practices or directing that specific steps be taken to stop the unfair discrimination, hate speech, or harassment. So your ladyship can restrain that, which is an interdict. H, an order for the implementation of special measures to address the unfair discrimination, hate speech, or harassment in question. J, an order that an unconditional apology be made, which your ladyship will see is part of the relief sought. And L, an appropriate order of a deterrent nature, including the recommendation to the appropriate authority to suspend or revoke the license of a person. Well, we emphasize the words an appropriate order of a deterrent nature. And then finally O, which is an appropriate order of costs against any party to the proceedings. My lady, if your ladyship is against us in finding that there is no jurisdiction, that your ladyship has no jurisdiction to entertain this complaint because journalists are not protected under the Act, then we submit, my lady, that the appropriate relief would then be to refer this matter or transfer this matter to the High Court. The reason we say that is if your ladyship looks at section 20 sub 3 of the Act, sub 3 says the clerk of the Equality Court must, within the prescribed period of receiving such notification, refer the matter to a presiding officer of the Equality Court in question, who must, within the prescribed period, decide whether the matter is to be heard in the Equality Court or whether it should be referred to another appropriate institution, body, court, tribunal, or other forum, the alternative forum, which, in the presiding officer's opinion, can deal more appropriately with the matter in terms of that alternative forum's powers and functions. Now, your ladyship wasn't the judge that was initially seized with this matter.
Case management, yeah.
In fact, your ladyship is the third judge seized with this matter.
Third? I thought I was the second.
No, my lady, third. I don't want to...
Okay, let's not go there.
Yes, but the first judge seized with the matter never made this determination that is under 20 sub 3 of the Act.
Okay.
Our submission is that what the Act is designed to do is it's designed to give relief pursuant to Section 9 of the Constitution in circumstances where that relief, where it is capable of giving such relief. But if a person comes to the court and that person puts forward a complaint which the court holds is not within its jurisdiction, the appropriate course of conduct is not to simply dismiss the complaint. The appropriate course of conduct is to find which forum is more appropriate to consider that complaint. And we submit that because your ladyship sits on other days in the same court as a judge of the High Court, that your ladyship can swap hats and refer the matter to your ladyship sitting as a judge in the High Court. In paragraph 44.1 of our heads of argument, we cite the case of Minister of Environment Affairs and Tourism versus George, 2007 3SA, a judgment of the Supreme Court of Appeal, dealing with the issue of concurrent jurisdictions. And the court held, given that the problem of concurrency will inevitably recur, the most productive and expeditious way of achieving efficiency would seem to lie in the matter being referred to the same High Court judge who, in his capacity as an Equality Court judge, is presiding in that court. So it may be that there's a claim where certain aspects of that claim falls under the jurisdiction of the Equality Court and other aspects of the claim falls under the jurisdiction of the High Court. The Supreme Court of Appeal says the judge sitting in the Equality Court must wear two hats and deal with the Equality Court matter wearing the Equality Court hat, deal with the High Court matter wearing the High Court hat. The Constitutional Court referred to George in the matter of DeLange versus Methodist Church, 2016 decision of the Constitutional Court. And at paragraph 58, the Constitutional Court said, in George, it was held that Equality Court proceedings and constitutional challenge proceedings may be consolidated for hearing before a single judge sitting as Equality Court and as High Court. There is indeed much to be said for this approach of permitting consolidation of disparate claims before a High Court. The consolidation will not only serve the procedural requirements of the Unfair Discrimination Act, which is the Equality Act, but will also avoid piecemeal litigation and costs. So, my lady, our submission is that our courts, both the Supreme Court of Appeal and the Constitutional Court, have quite clearly said there is no problem with a High Court judge wearing two hats. Bearing in mind that the machinery of the Equality Act is such that when a complaint comes in, if it's not a complaint that should properly be before the Equality Court, then that complaint can be referred to an appropriate forum, including the High Court. If that is the machinery of the Act, we submit that there would be no difficulty standing in your ladyship's way of, if there's a finding against us on jurisdiction, simply transferring the matter to the High Court and considering the matter as a High Court judge would consider the matter. In which case it would then be argued on general principles of interdicting harm. So, my lady, I'm not suggesting that this court doesn't have jurisdiction, but I'm making the submission that if when your ladyship writes the judgment, it might be that we have to come back for a second round of argument in the High Court. My lady, if your ladyship finds that this court does have jurisdiction, then and only then would it be appropriate to move on to the question of the strikeout. We have in your ladyship's bundle of cases a judgment of the High Court in the matter of Brown versus the Economic Freedom Fighters and Mr. Malema. And that had to do with a case where Ms. Karima Brown took the Economic Freedom Fighters and Mr. Malema to the High Court for a breach of the Electoral Code. And it was for publishing Ms. Brown's telephone number on Twitter. And I'm going to be referring to it's in your ladyship's bundle under B. I'm going to be referring to this case later on, but just for purposes of the application to strike out, I'd like to refer your ladyship to paragraphs 23 and 24 of the judgment. '23, I won't read it out, but the respondents had sought a determination on the question of jurisdiction before as a point in limine. And the learned judge held in 24, a determination of the question of jurisdiction must be made before any other issue, because without jurisdiction, this court has no power to make an order in this application. It does not, however, mean that the question must be determined separately and in isolation before argument on any other issue can be presented. So the point we make is a simple point. It's not, it's also trite. If your ladyship finds that there's no jurisdiction, then your ladyship can't proceed with the matter. If your ladyship finds there is jurisdiction, then we come to the application to strike out. Now, it's correct that the claimants seek a final interdict, and so therefore the test in Plasko and Evans Paints will apply. So your ladyship will have to decide the matter on the facts as alleged by the respondents, and I've already submitted to your ladyship that there are very few facts that are alleged by the respondents. But nevertheless, on those facts, together with the facts alleged by the complainants that are not denied by the respondents, and it's not denied that all of those statements were made. It's not denied that all of those tweets were published. None of that is denied. So your ladyship can decide the case on on the statements published by the respondents, the tweets published by the respondents. And your ladyship can also decide the case on the fact that the respondents have done nothing to dissuade their supporters from their hate speech and harassment which is directed against the complainants. I think there are two emails that the leadership of the EFF sent to structures of the EFF dealing with the behavior of members in the course of industrial action or strikes. That's the only time that the respondents have sent out any statement calling their supporters to order. And then, of course, there's also the statement made by Mr. Malema in his speech outside the Zondo Commission, where he said, "And don't kill them." But I've already made submissions on that. So, my lady, we make the submission, and I submit it, it's evident from what I've already argued to your ladyship, that all of these tweets are in fact relevant to the dispute that your ladyship needs to decide. And therefore, once they are relevant, there's no basis to have them struck out at all. Because the major test for striking out is relevance. The respondents' argument as to why they're irrelevant goes back to what I argued before the tea adjournment, and that is that everything that the complainants have to say is not said in their own right as complainants, because they are not truly complainants before the court. But if they are complainants before the court, their evidence is there. But in any event, my lady, even if they're not complainants before the court, which I don't concede, the evidence that they've adduced is relevant to the relief which is sought in Annex B. Because it besides the fact of how they felt about it, it highlights the conduct of and the tweets of the respondents. It highlights the conduct and the tweets of their supporters, and it highlights the fact that the respondents have done nothing to restrain their supporters from the hate speech and harassment and abuse that is directed against the complainants, the individual complainants. Milady, but we have, besides the fact that all of that evidence is relevant, in the sense that there's no dispute that the tweets were made on the dates and at the times that they were made by the people whose names appear thereon. Besides all of that, the proceedings in the Equality Court are slightly different to the proceedings in the High Court. And the Act says that the proceedings in this court will be in the form of an inquiry. I'm at paragraph 49 of our heads. Section 19 of the Act sets out the rules and procedure of this court. Rules and court proceedings. Section 4.1 of the Act says that in the adjudication of any proceedings, they must be expeditious and informal. So our submission is that this, although we're sitting in the High Court now and we've got very formal proceedings underway, that this inquiry actually is meant to be informal. We refer to the case of the South African Human Rights Commission and Kwelani, which is 2018 decision of the Equality Court, where this court said it is equally plain that access to the Equality Court does not have the traditional and restrictive procedural red tape. The procedure thereat is also aimed to be informal, as mirrored by sections such as Section 21(1) of the Equality Act, which refers to an inquiry. In my view, all of this points to the fulfillment of the right of access to courts as enshrined in Section 34 of the Constitution. What the respondents want your ladyship to do is to decide this matter by excluding whole swathes of evidence of tweets that were actually sent and put or published in the public domain. They say your ladyship must close your eyes to that evidence. And we say that, or we submit that by virtue of Section 3.3 of the Equality Act, that this court must have regard to the effect of the respondent's conduct on the complainants and the personal experiences of each of them. We quote the National Coalition for Gay and Lesbian Equality case at 54.1. We say that the approach of this court has been to include evidence no matter how broad, and again we refer to the AfriForum and Malema case, where the court said that it allowed much evidence to be laid, which would not normally be permitted in a court of law, as it appeared to me that it was proper to allow the parties to the dispute to fully and completely ventilate the issues between them. Even if such ventilation involved the admission of evidence in the form of speeches which were made during the course of the trial, in the form of documents which contained hearsay matters, and in the form of witnesses who gave evidence, the ambit of which was far beyond the issues. Now, my lady, I'm not suggesting that is what the evidence in this case constitutes. I've already made the submission that it's not hearsay evidence. I've already made the submission that it's evidence that is relevant to the relief which is sought, and it's relevant to the case that is made out of hate speech and harassment. But the point that we are making is that this court, sitting as the Equality Court, has not taken an approach which seeks to exclude evidence, but has rather followed an approach which seeks to include evidence. And then finally, we make the submission that Section 19 of the Act, when it incorporates the High Court rules, it does not incorporate the High Court rule dealing with striking out, which is Rule 23. And your ladyship will see we've quoted Section 19.1, and it is clear from that provision that it doesn't include Section 23, Rule 23, I beg your ladyship's pardon, of the Uniform Rules of Court. So we submit that the application to strike out has no merit. But there's an alternative to the application to strike out, and that is the application to refer certain allegations to oral evidence. Milady, this is an unfortunate application because it only focuses on Ms. Moonsang, and in particular paragraphs 38 to 45 of Ms. Moonsang's affidavit. That your ladyship will find starting at page 81 of the papers. The EFF says that it can't rebut this evidence. And so if it's not struck out, then the respondents, the EFF and Mr. Malema, must have an opportunity to cross-examine Ms. Moonsang on this. And what she says in her affidavit is, well, starting at paragraph 38. She says that, well, earlier in her affidavit, she describes Mr. Malema's speeches, she describes her interactions with Mr. Malema, and she says she's begun to feel the impact of working in a hostile environment, and it's had an impact on her emotional well-being and her ability to continue to work professionally. And the respondents want to challenge the allegation that the cause of her breakdown was Mr. Malema's tweets and the hostile tweets that followed. So they want to cross-examine Ms. Munsemi on why she's having difficulty working. Paragraph 39, that she felt completely overwhelmed and began to cry. The fact that she then went into the office of one of her colleagues and she broke down completely. There's also, all of this they want to cross-examine Ms. Munsemi. And then she says in her affidavit in 41 that former state security operatives have warned me to take security precautions and to be careful because I may be in physical danger. She says, I do not want to be forced to employ private security personnel to protect me. I believe that this will impede my effectiveness as a journalist. But then she says that there were events on the 23rd of November, 3 days later, which forced her to reconsider her decision because at about 6 p.m. on that day she visited a shopping center near her house. And she doesn't want to disclose the precise location because she doesn't want a repetition. And while she was shopping, she noticed 3 men looking at her, and they repeatedly called out her surname in a mocking tone. She tried to ignore them, and then as she passed them, they hissed at her and shouted her name. And the respondents say, in relation to the security operative, she doesn't give the date when she was contacted. She doesn't say how many interactions she had. She doesn't say how she was approached or why. She doesn't say why she's in contact with such persons. She doesn't say why those persons might be monitoring her and the EFF. In relation to the mall, she doesn't give the name of the mall, and so on. And so it's on this basis that the respondents say, if you don't strike out this evidence, milady, we want Ms. Munsemi to be put in the witness box and we want to cross-examine her. But
the other concern is that there was no confirmatory affidavit from all the people who are mentioned in the founding affidavit. Yes. That's the respondent's other concern.
That is, they say that the colleague hasn't put up a confirmatory
affidavit.
Yes. Milady, if your ladyship should find, despite my argument about Rule 23, that Rule 65G, which is also not a rule mentioned in Section 19 of the Act, if your ladyship should find that Rule 65G applies, then your ladyship will have a discretion whether or not to refer a matter to oral evidence. But that discretion, if I may just read the opening sentence of the rule, it says, where an application cannot properly be decided on affidavit, the court may do certain things, including direct that oral evidence be heard on specified issues with a view to resolving any dispute of fact. Our submission, milady, is that these issues that the respondents raised in relation to Ms. Munsemi's affidavit are so peripheral to the issues that you have to decide that these are not issues that warrant a referral to oral evidence. So, because even if your ladyship should find that Ms. Munsemi broke down and cried, or that she broke down completely, or that she was warned to take security precautions, or that she was hissed at a mall. That is not going to help your ladyship decide the ultimate questions that your ladyship is called upon to decide. And that is, has there been hate speech? Has there been harassment directed against the complainants and other journalists? If so, can the EFF and Mr. Malema be held liable for the statements they made and the statements made by their supporters, to the extent that they failed to call upon their supporters once those statements came to their knowledge, to stop it, to leave the journalists alone, not to behave in that way? So it's that question, besides the question of jurisdiction, that your ladyship is called upon to decide. Because if you go to the relief which the complainants seek, which is Annexure B, page 8, the relief sought is to interdict the respondents from intimidating, harassing, threatening, or assaulting, to interdict the respondents from publishing personal information, to interdict the respondents from expressly or tacitly endorsing the intimidation, harassment, threats, or assaults on, interdicting the respondents from expressly or tacitly endorsing the publication of personal information of, directing the respondents to publicly denounce the harassment and abuse of the 2nd to 6th complainants, etc., etc. And then over the page, directing an apology and costs. So, my lady, whether or not Ms. Munsemi broke down is it might be a consequence of the hate speech. It might not be the consequence of the hate speech. It's not irrelevant to the extent that it has to be struck out, but your ladyship can give it the weight it deserves. It's not a finding that is going to be decisive one way or the other in relation to the relief that is sought. If your ladyship should find that Ms. Munsemi was accosted at a mall, or threatened with assault at a mall, the respondents, it's the respondent's reaction to that is important, not the fact that she was assaulted or threatened to be assaulted at a mall. So your ladyship will see in the papers that when Ms. Munsemi tweets about this, about being threatened at the mall, supporters of the EFF say, well, if that happened, we don't believe you, but if that happened, you deserved it. It was coming to you. I think they use the word karma. It was coming to you. This is in line with lots of tweets from lots of EFF supporters against numerous journalists, that you deserve what you're getting. You are, in fact, what is said about you. You are a witch, and so on and so forth. It's in that context that the respondents need to call upon their supporters to stop. So it doesn't matter whether the incident happened or not. What matters is the respondents' reaction to the conduct of their supporters in attacking journalists such as Ms. Munsemi. So none of these grounds that, or areas of Ms. Munsemi's affidavit that the respondents want to pursue further by way of cross-examination is going to assist in that regard. On the key issues in this case, milady, there are no disputes of fact. I've made that submission. And milady, it's curious that the respondents are only seeking to cross-examine Ms. Munsen. The reason I say that is because the other complainants have also stressed that they fear for their safety, that they fear for the safety of their family. I can give your ladyship one example, and that is in the affidavit of Mr. Bateman. Your ladyship will recall that there was the tweet. This is at page 232, paragraph 15. A list of Stratform journalists' home addresses would be a good Christmas present. And then Mr. Malema retweeted that to 2.26 million followers. And then there was a response to the tweet which says, we will also visit them peacefully. And it bears a picture of a man with an axe in his belt. Mr. Bateman says, Mr. Malema appears to have reversed his tweet of the comment, but the message was already seen by his followers and supporters. It is evident that some of Mr. Malema's followers use the same rhetoric. He describes that. But then he goes on to the issue of the Vodacom Journalist of the Year Awards, which is at paragraph 20, the tweet from Dr. Ndlozi, the tweet from Ms. Nkalipi. And he says, I submit that these incidents demonstrate the proclivity towards extreme violence and intimidation by the leaders of the EFF, as well as its supporters. The utterances of the leadership of the party has made me and my family fearful of being physically attacked. I believe that Mr. Malema's retweet insinuates that the addresses of journalists should be obtained and disseminated in order for EFF supporters to threaten, intimidate, or physically harm those journalists whom the party deems desirable. And then in 27 he says, I believe that Mr. Malema and his supporters have targeted me and my family directly. I fear that they will soon harm me and my family merely because I reported on Mr. Malema in a way that did not find favor with the EFF or its supporters. And he continues in the same vein in paragraph 28. It's precisely what Ms. Munsen is saying. She's also saying, I'm fearful, I broke down. It's important for your ladyship to hear what the complainants say the effect was on them, but it's not going to be decisive on how your ladyship rules as to whether or not the complainants are entitled to the relief. So. I'll leave the other issues in the strikeout application for reply. I don't think that I need to raise the skittles now. So, my lady, I move to the final section, which is the final interdict. The requirements are trite, and that is, there are three requirements: a clear right, an injury actually committed or reasonably apprehended, and the absence of a satisfactory alternative remedy. We say in 62 under clear right that the relief that we seek in this case is founded on the complainants as journalists, their right to freedom of expression and dignity. As journalists, they have the right to work without being subjected to intimidation, harassment, insults, threats of physical violence. We also say that the complaint is founded on a number of public statements and social media posts, and we listed those all when I dealt with a different issue, but it's those same statements that I've referred to earlier. I'm going to focus, my lady, on Mr. Malema's speech of the 20th of November, because that receives all the attention in the answering affidavit. My lady, I'm moving to paragraph 66 of our heads, where we say that the respondents took no steps to call their supporters to order. The reference there is to the affidavit of Ms. Matlasi. Now, this is at page 21. The first time that we can say that the respondents were made aware is in Annexure MM 18, and that was the tweet of Ms. Ferrell Hafferty, which I referred your ladyship to earlier, where she says that journalists get attacked by the EFF trolling army. It happens every day. Once marked like this, it's open season. And then Mr. Malema says, it won't end. You are Ramaphosa Defence Force. Just start acting professional. It will end automatically. Then at paragraph 34, page 21 of Ms. Matlasi's affidavit, she says, the respondents have also refused attempts by the first applicant to resolve the dispute between the respondents and the media. So your ladyship will see there's reference there to MM20, which is a letter that Ms. Matlasi sent to Mr. Malema on the 26th of November 2018, requesting a meeting with the EFF to discuss the issue of the safety of journalists. Sanef is worried about comments you and EFF leaders have made that have singled out and named particular journalists. In the wake of these comments, these journalists have been exposed to physical threats and cyberbullying. And then she goes on to talk about decisions to ban particular publications from interviewing him. And she says, we would like to meet with you at your earliest convenience. The response to that is the letter at page 66, MM21, which comes from the Secretary General of the EFF, Mr. Godrich Gardi, same day, 26 November. And he writes to the chairperson of Sanef, Ms. Matlasi, and he says, we refer to your letter, and we want to respond as follows. Your letter reads to indicate that Sanef would wish to meet the EFF leadership. All correspondence to the EFF should be addressed to the Secretary General, as it would be a norm in many organizations and not an exception in the EFF. It is not acceptable to write to a president of any organization when requesting a meeting with the leadership of that organization. The schedule of the EFF is very tight and fully booked with pre-arranged meetings and activities up until the elections date, and in the circumstances we are unable to accede to your request. Elections were in May. This letter was sent in November of the elections were in May of 2019. This letter was sent in November of 2018. So as Ms. Matlasi says, at page 22, paragraph 35, there was another request for a meeting, which is MM22 at page 67. And this time, taking the taking Mr. Gadi at his words, now writes to the Secretary General of the EFF. She says in paragraph 2, one of Sanef's strategic objectives is to defend media freedom. In 3, she says this does not mean that journalists are beyond reproach. Those who believe they have been wronged by the media have recourse to the law or the complaints mechanisms created by the Press Council and the Broadcasting Complaints Commission. We also accept that the political discourse in South Africa is often robust and that the media may legitimately be criticized on public platforms. What we do, however, object to is when individual members of the media are publicly targeted, resulting in harassment, intimidation, and/or threats. Such conduct not only serves to infringe on the relevant journalist's physical integrity, it may also serve to inhibit the free flow of information to the detriment of the public generally. The courts have previously condemned such conduct by members of political movements and have interdicted such behavior. And then she quotes in paragraph 5 about the speech on the 20th of November, where Mr. Malema singled out several journalists by name, calling on his followers to attend to them decisively, branding them as the enemy that need to be crushed. When the enemy raises its ugly head, don't hit the head, cut the head, Mr. Malema said. She says in paragraph 6, which is what has been said in the papers of the complainants throughout this matter, that in uttering these statements, Mr. Malema has created an enabling environment for these journalists to be targeted. In the result, they've been branded on social media as mercenaries, with supporters claiming that Mr. Malema has given them a mandate to deal with them decisively until they become carcasses in their brains. Your Ladyship will find that tweet referred to in the chronology. Some have been threatened with messages such as Indian cabal, we are coming for you. Some were branded, and I'm not going to repeat those words. In addition, at least 2 of the journalists concerned have experienced physical harassment and threats in public spaces. And then she makes the very clear point: the failure by the EFF and its leadership to distance itself from these utterances and actions has only served to make the situation more volatile. We are seriously concerned about the safety of these journalists. She says on the 26th we proposed a meeting. It was rejected. The threats and harassment have continued unabated. The situation has been further exacerbated by threats of revealing the addresses of the journalists in question. Your Ladyship will recall that was the tweet that was retweeted by Mr. Malema about a Christmas present. Then she speaks about Mr. Poe and Sanef's condemnation. And then she calls for an urgent meeting with Sanef. We note that after people claiming to be EFF supporters vandalized at least two Vodacom shops this week, the party leadership met up with Vodacom and the matter was reportedly resolved. We firmly believe the same may be achieved in this matter. And then in 12, she asks for a meeting again, and she says, please can you come back to us by no later than Wednesday the 12th of December? And there's no response. And hence, on the 12th of December, or I think it was the 12th of December, this complaint was instituted. My lady, I see I've gone over time. Perhaps
13th of December.
13th, yes, that was the next day.
Yeah.
But since this letter was sent until today, there's been no meetings between Sanef and the EFF. In fact, there's been no response to this letter at page 67. I'm sorry, my lady, would this be an appropriate time to take an adjournment?
Yes, I think so.
Thank you, my lady.
Thank you. We'll adjourn.